So today I'd like to talk about generative AI usage guidelines that we've drafted. The standard trademark disclaimer. Before we begin, though, just wanted to mention, because this has come up in a completely unrelated context, that the Eclipse contributor agreement is signed by contributors who are not committers. Committers don't actually need to sign this agreement. Is signed by contributors, and it is valid for 3 years, which basically means after 3 years it expires. Our current implementation doesn't actually yet work with the contributor to, warn them in advance. So this is something we've identified as a problem, and we're going to address it. But in the meantime, ECAs just expire. We do have a number of them coming due in the next little while. There was a big glut, I guess, of ECA signing in pardon me, in about this time of year 3 years ago. So a bunch are coming due. I actually kind of looked through the contribution records. I'm pretty sure that almost none of them are active contributors. In fact, most of the people affected have contributed nothing. So I don't expect this to impact anybody, but just in case, again, it's just an unusual volume of them, to just be mindful of that. And again, I will reiterate that committers do not need to sign the ECA. The ECA is actually already rolled into your committer agreements. So the individual committer agreement and the member committer agreement include this. So by virtue of you working as a committer, you've already, this has already been agreed to either by you or on your behalf, if you work for an organization. As with any discussion of things that might be considered of a legal nature, I am obligated to remind everybody that I am a software developer by training, not a lawyer, solicitor, barrister, or attorney, or whatever variation of person who practices law is in your particular jurisdiction. Consider the information today as entertainment, not legal advice. And again, just so you know, if you ever do need legal advice, you can't really take legal. You can, I guess, but it's bad. If you want legal advice, you should talk to somebody you are paying for legal advice. Somebody, getting advice from a lawyer is probably also not a good idea unless you employ that lawyer. This is just sort of generally how the law works. There's a great scene in Breaking Bad where Saul is basically telling Walt that he needs to pay him $10. I can't remember what it was. And then once he paid Saul, he could give him legal advice, right? That's actually sound legally. Anyway, just distraction. So again, not a lawyer. I will use a lot of modal verbs like may, might, can, could while I'm talking about things of a legal nature. We have published a set of guidelines, the Generative Artificial Intelligence Usage Guidelines for Eclipse Committers. There's a URL there. I've provided it in the email that I sent out earlier, and I'll include this in the notes for the presentation. So we're talking about this because of GPT, Generative Pre-trained Transformer, just in case you, like me, needed to look up what that stood for. GPT technology doesn't actually copy content. Rather, it forms content based on connections it learns from training data. So when GPTs generate content, it's not a copy, which kind of introduces a gray area. It's not actually copying directly content. In some sense, though, a GPT can be said to have access. When it generates some substantially similar content from training data, there is some risk of copyright infringement. I'll talk a little bit about this, but I really can't get into it too deeply because, again, not a lawyer. How do we assess the risk? I don't actually know. How do these risks compare between GPT generation and a human just coincidentally writing something similar? Again, I don't really know. Our best advice is to use the GPT that is able to cite its references or similar tools that allow you to compare generated content against training data, and that you use those references to make a judgment regarding whether or not the generated content is substantially similar, or if it might be considered like boilerplate or rote content. I'll talk a little bit about that in a bit. If you haven't read about the monkey selfie copyright dispute, I recommend it. Solid entertainment. AI generated content cannot be copyrighted. If it can't be copyrighted, it can't be licensed. Um, Curation, however, is a copyrightable act. When you modify AI generated content, your modifications are yours. Um, so that kind of, again, introduces a little bit of grayness into the process. Um, Modifying AI content does not automatically make the AI content copyrightable. Your modifications. There was one example that's cited is using an AI to generate images. The images themselves are not copyrightable, but if you take those images and put them into a particular order and add captions and put them on a website, all of the things that you did are actually copyrightable actions. Yeah, anyway, so our definition of, the definition that we follow of intellectual property, intangible assets created through human intellect. There's case law dating back into the 60s about this, and again, the general consensus among the legal circles, and precedent set in court is that generated content is not copyrightable. Our own agreements also use wording that is important. The DCO that contributors sign basically says, the contribution is created in whole or in part by me, or that I have the necessary rights. So there's some work there's some the DCO still basically works, except again, we talk about contributions as things being created by humans, and generated by AI becomes a bit of a gray area. So I did mention that I am not a lawyer. I believe I labored that. Wholesale copying of somebody else's work and claiming it as your own is, I think, a pretty obvious example of copyright infringement. If you observe somebody else's work and then re-implement it yourself, and the result is substantially similar to the original, you may have infringed on copyright. What constitutes substantially similar varies by jurisdiction and case by case. Many organizations go to great lengths to ensure that their own developers don't observe other work to mitigate against infringement claims. So can the construction of an LLM be considered observation of somebody else's work? Some people do think so. Fair use is another gray area that varies by jurisdiction. Parody is a form of fair use. A musician sampling segments of a song might be fair use. Criticism, comment, news reporting, teaching, scholarship, and research are all areas of fair use. How does fair use apply in this context? Certainly using generated content as an example. Sorry, I shouldn't use the word certainly. Probably, using generated content as an example would be fair use. Again, sample, pieces of other people's content, pieces of generated content may be considered fair use. Again, I'm not a lawyer. I don't actually know the answer. The term de minimis originates from Latin. It's actually, in law, it's a slightly longer term that I don't quite remember, but it roughly translates to the law does not concern itself with trifling matters. De minimis might apply, for example, when a contribution fixes a spelling mistake, right? So, a couple of lines of code here, or, we don't actually think about getters and setters as being AI generated content, but like a getter or a setter, like it's just nobody cares, right? It's, something relatively small and not interesting. Boilerplate or rote content might fall into this category, right? So, I was tinkering around with one of these GPTs, and I had it create an Eclipse plugin for me. And it did a pretty good job of, creating a plugin.xml file and a manifest file and all of the various bits and pieces. But terrible job on the logic, which I went in and filled in, right? So getting the GPT to generate that boilerplate and then modifying the boilerplate probably falls into the de minimis. Nobody actually cares. Rote, ROTE, that's basically that means, if if five of us were to sit down and do a thing, we'd all do it exactly the same way because that's just how you do it. That may also fall into the de minimis category. Yeah. Yeah, it's as soon as you start doing, like, when you say, "Hey, that's darn clever," that's when you start to really need to be careful about the content that's been generated. Something I didn't actually mention, our guidelines are more or less the same, more words, slightly different words than what the Apache Foundation is doing. So nothing I'm talking about is any different from what other foundations and other organizations have observed. So a little bit about the guidelines themselves. We basically list a couple of things to consider. First off is understand the technology. All of the AI platforms have various strengths and weaknesses. Some are better than others in certain use cases, and understanding these will help you have realistic expectations. Again, just make sure you understand things like, where, having a sense of what training data it's built on and like where it's getting its information from is an important consideration. The terms of use, we've found some interesting things in some of the terms of use. And if you need help with this would be a good thing, good opportunity to reach out to EMO, and we'll try to help you understand. ChatGPT has this clause in its terms of use, which basically says you can't use the generated content to make a competitor. Right, which kind of is a red flag. That's violates the fifth rule of the open source definition, field of use restriction. Is that number 6? Anyway, so yeah, so some of these AI platforms have terms that preclude the use for competitive purposes. Make sure you understand the terms of use. These just it's just good citizen stuff, but sometimes there's things in there that may not be obvious. It's also important that you make sure that your use of these technologies is consistent with your contract, your contract with your employer. Your employer may have some rules regarding the use of this sort of technology. It might be a good idea before you leverage it, even to contribute to an open source project, to make sure you don't run afoul of those any limitations placed on by your employer. Most of the major paid generative AI platforms state that they will not use your inputs for training purposes. That is not the case for all generative AI platforms. So just be aware that the inputs you provide may wind up being used in some way. So this is just sort of our kind of a keep yourself safe. Don't provide personally identifiable information to these generators. Avoid putting any content that you might consider to be confidential. When I tinker with this, I change the names to protect the innocent, and that sort of thing, and then change them back when if I get something useful back. Use the tools that are provided. So at least some of these platforms, I tend to tinker with u.com. One of the things that u.com does is it cites its references. So when it includes content or when it generates content, it tells you where it made its connections, right? So it'll point you back to the Wikipedia page, or it'll point you back to, again, the Stack Overflow article that it may have made connections from. Use those sorts of those sorts of tools if you can. Some of these platforms also have means of determining whether or not the generated content is substantially similar to some of the training data. And then some of them will adjust their output based on just automatically adjust their output based on determining that something is substantially similar. Of course, these are AI tools making their own determinations. So again, at some point, a certain amount of judgment may be required from you as a committer. Verify the accuracy and vet the output. This is all very, very powerful, but it is prone to errors. I have found, for example, that these generative AIs are terrible at doing limericks. I'm not sure how that helps us as software developers, but just an observation that it doesn't necessarily get things, right? Or of course, it doesn't get things at all. It just makes connections. Make sure that any content that you use that might be generated goes through our normal vetting process, all the different sorts of things you can do. Be aware that there are, in addition to intellectual property concerns that I have with my team, there's also security concerns and supply chain management concerns. We need to make sure that we're not introducing content. And of course, again, just bear in mind that as committers, the content that you introduce into your projects, you bear responsibility for those contributions, and you have some responsibility, at least morally, to the community, to make sure that the content that you're adding is been properly checked over, right? And this is true of just contributions we receive from the community. There's a rather I'm sure well-known case to everybody recently where a project was compromised, and how do we vet against contributors who are malicious, right? Just we have to we have some responsibility to our community to make sure what we're accepting into our projects is safe for consumption. And then, of course, be transparent. If you are using any or including any generated content, cite your references, quote your sources. I've put an example here, and we're kind of still just evolving this as a part of a the larger community. In my header, I've just put this comment that some portions were generated by Copilot. I've actually not used Copilot myself, so this is entirely bogus from my perspective. But again, just a comment that some portions, if you can be specific, great. Chances are being specific will be hard, but if you are generating content, please make sure that is made known, right? We don't hide the fact that we're doing it. Not that anyone would do that, would hide anything. All right, I'm going to they got a couple of questions. I'm going to wrap up the formal part of the presentation, and then raise it. Then we can open for questions.